Hi friends from around the world. So we are still in the thinking of opting out and not opting out. And we need to know a bit what is the court proceedings, right? What is expecting us at the UPC, whether we want this or not. So we will talk about the structure of the UPC system and about the proceedings a bit. What can you expect when you litigate in front of the UPC? Now, the first thing I talked you through in the last video on three legal instruments. One was the UPCA, the Unified Patent Court Agreement, then on the rules of procedures of the UPC, and finally on the court fees and recoverable costs. Now, these are legal instruments with a different ranking. So to say, the Bible, the highest ranking would be the UPCA, the Unified Patent Court Agreement, that one which is ratified by the contracting member states. Now, there are all of the important things are, so to say, in there, but it is a high-level ruling. So the proceedings are detailed in the rules of proceedings of the UPC, which is, so to say, more detailed but cannot contradict what is the Bible, the UPCA, right? And then, for ease of adapting so the UPCA, you need all the member states. So in order to adopt a new UPCA, that is very difficult, you can imagine. Whereas the administrative committee, which is responsible for the court fees and recoverable, etc. So this is easier to adapt, and therefore it is still a different legal instrument, but easier to adapt, and still in a ranking was inferior. So it's just about what are the amounts, because this is important for the budget of the UPC, which lives on the court fees, right? So that was about the legal instruments I wanted to clarify. Now I come to the structure of the UPC. And there we have the central division, naturally, which has three branches. One in Paris, where the headquarters is, another in Munich for some types of patents, and a third was foreseen in London. Due to Brexit, London is not anymore an option. So it has not been decided whether there would be a third branch somewhere, or whether what has been foreseen to be consumed by this third branch will be absorbed by the other two. Anyway, we have The Hague and Milan as candidates for this third branch. Now, the central division is competent. Here you have on the screen Article 32, is competent for non-infringement proceedings and invalidity proceedings with or without counterclaim, and for other types of proceedings. Whereas you have, on the other hand, local and regional divisions as well. You may recall from the trademark system, the European trademark system, we have European trademark courts in each member states. Well, here we have, so to say, local divisions or regional divisions in each member state or in each region. Now, depending on the workload, in one country you have not many, in others you have very much. So you may have up to 4 courts according to the workload in one country and only one in another. Or you have small regions like, I don't know, the Benelux, for example, where they have one trademark system, you may remember. So they may also think of a regional court regrouping things of these 3 countries. Now, the you have the principle, what is exclusive competency of the central division, and then you have what is, so the infringement actions, for example, that would be typically presented within the local and regional divisions. Here on the screen, you have a system, how it is foreseen. So you have the local and the central division, and then it goes further down to an appeal court, which we have as well. The appeal court is in Luxembourg, though, so not in Munich, not in Paris, but in Luxembourg, where the European Court of Justice is being located. So this is the structure, so to say, what we have with regard to the UPC, but we have also a kind of mediation center, which is still located in a different location in Lisbon and in Ljubljana. It is free for you to adopt the alternative dispute resolution method or way. Probably you are encouraged by the judge rapporteur or by others during the proceedings to use them, but you have no obligation to do so. It is just an option. Then you can opt out probably and go further with the court if you want so. But you know, alternative dispute resolutions, it is encouraged, but it is not too much used as I can recall from the trademark part where I'm mediator for trademark, but it was not too much used by the parties, and it is only in some cases where it is probably worthwhile to explore. So this is the structure, the whole structure of the UPC. Now I want to go a bit into the proceedings of the court. So if you are familiar with what are the proceedings in the Court of First Instance and the European Court of Justice for the trademark cases, then you will not find very much astonishing things here. The principles are the same, so transparency, equality, etc. So these are the same, and also the electronic filing system, that is also the same. With regard to the proceedings, so to say, we have 3 steps. One would be the written procedure, followed by the interim procedure, and then the oral, so the hearing, so to say, the oral procedure, and then we have the judgment. So that is the general framework within how that works out, and we have, so to say, the same level of proceedings within the appeal court, the court in Luxembourg. Now, what are the different proceedings? Written proceedings first. Well, written proceedings are where the claim has been presented, and perhaps a counterclaim may be presented by the defendant, or the brief on its defense is being presented by the defendant, and perhaps there's another round for arguments, for presenting arguments, so the replique and the duplique. This, so to say, would be the normal way how it works out. The interim procedure is so this is going to the court and is transparent, so everybody has the same documents, right? So you have to present the sufficient documents so that it can be sent from the court, from the registry, so to say, to the other party, so that everybody is on equal, has equal weapons and transparency on what is presented, on what grounds the decision will be taken. The interim procedure after you have presented, the parties have presented their arguments, is in order to give the juge rapporteur or the panel to give them the possibility to direct, to ask questions or direct the proceedings in one or the other way. And this is followed by the oral proceedings. Oral proceedings, we have this as well in the trademark system, the trademark appeal system, and it has been used, normally oral hearings for every case, but over time it is even less used. I think now 50% only has the oral proceedings, and it is so, according to the UPCA, that if the court sees no necessity to hold oral proceedings and the parties agree not to hold them, then there are no oral proceedings. What are the oral proceedings for? Well, the parties are there to present in person their pleadings, so to say, and then there may be witnesses, there may be experts, there may be clarifications, questions from the court, there may be discussions on some issues. So the different documentation must be presented, perhaps the original document of this or that one, which has been presented as evidence in the written proceedings or so. So this, or the parties may be heard on or questioned on one thing. Well, these are the oral hearings, but if that is, so to say, clear, in trademark cases it is normally clear. Everything can be presented in written, but here a patent, so perhaps you need to see it. So it may be, but oral hearing anyway, it is in person, but it may be organized virtually, right? So you don't need to go to Paris, to Munich, or to Luxembourg. That can be done after pandemic. It can be done probably also per Zoom, or at least the court probably is thinking about that possibility. Now, some two final notes I want to go over. One is the languages. So the languages is always some kind of problem within the European Union. We have 23 languages. I don't know how many languages we have with the contracting member states. So the Poland is not in and Spain is not in. So we have less, but still many official languages, so to say, which can be used in the proceedings. Now, normally it is that the language in the court is the one in which the patent has been granted. That would be the language of proceedings. Or it can also be that the parties, they agree on a different language, and if it is still a language of the contracting member states, that is a minimum requirement. But then the court may be in agreement in order to go to that other language. So there is, what my point here is, there is some kind of flexibility with regard to the language regime where you want to go in, and this is an important issue. Although I think English is one of the most common languages in the trademark system. We have 50% of the proceedings is in English, so this will be no different here as well. Now, the last remark is with regard to representation. What about the representation? Individuals cannot represent themselves in the UPC system, neither in the court of first instance or in the appeal court. They must be represented by either a person who is a qualified lawyer in one of the contracting member states, or it must be a person who has undergone a European patent attorney exam. within the notes, I give you an indication, a link to a page where you can see all the institutions around Europe which have been agreed and licensed, so to say, upon making an examen for the European Patent Attorney. So if you are interested in one of those, you have the link here, and you can choose of the institutions which have been licensed to do so in order to take that exam. So just for your information. So let me wrap up this for you. We have the UPC system, which is very much not the same, but very much in line. I think what I know exactly from the trademark system. We have the rules of procedure, which are based on the UPCA agreement and which are, well, they have the same principles and the same, so to say, proceedings with regard to the round of presentations of the briefs and the oral hearing, etc. So it is not something which is very astonishing to you. The alternative dispute resolution is still there. It's a possibility, but you normally would not envisage this ADR. The registry is in Luxembourg, together with the main court, the appeal court, whereas you have registries which are sub-registries, so to say, in every local and regional division, and then the central divisions as well. They are responsible for the proceedings, how they are developed, the sending of the briefs to the other party, so making sure that everybody has the same level of knowledge with regard to the case. And the substantial proceedings, you have to look at the where are you, so the written proceedings, the interim proceedings, and the oral proceedings, if any. In the future, probably it will be less in the future, and it will be more in the beginning. So in order to get the train running, so to say, they will probably to hear more in person, but then afterwards they will say, well, it is not worthwhile repeating always the same thing. So representation and languages is the other issues which we have discussed here. So thanks. You should know now more about the UPC system than before.